Yes.
Mr. Fenwick, a few questions which have been raised by call participants,
Yes.
so I'm afraid there'll be some jumping about.
Sure.
First of all, the HIV litigation and Scotland and Wales.
And what?
And Scotland and Wales.
Yes.
Now, we know that some claims were brought in Scotland concerning infection with HIV through the use of blood products. Did you have any role in advising on claims that were brought in Scotland?
Not as far as I recollect.
Are you qualified in Scottish law?
No. So, I mean, it is conceivable that the department asked me questions relating to litigation in Scotland, but I would not have been acting in Scottish cases or advising the Scottish authority. To
the best of your recollection, were you aware of these ongoing claims in Scotland at the time?
I don't remember them now. I have no idea whether I was told at the time.
And I think it probably follows from that the answer to the next question is already answered. But do you remember having any liaison or coordination with anybody in Scotland about those claims?
No, I'm pausing because there was some other litigation which involved some interplay with Scotland, but I don't have any recollection of anything to do with HIV.
Moving on then to Wales, documents which we didn't provide you with indicate that the Treasury Solicitor was acting not only for the Department of Health but also for the Welsh Office in respect of claimants who had been infected in Wales.
Yes.
Do you recall whether or not there was any significance to the claim about the fact that the Welsh Office were also part of the litigation?
No, I don't. I mean, I think that very often Wales is treated the same as England, whereas Scotland is not because of the way devolution was working in 1990. There were, of course, a number of other defendants, and I can't now remember who they are, but looking at some of the documents, whether the Welsh Office were a separate defendant or whether it was dealt with them well, I don't know, but there was certainly nothing different in the way that I acted because of Wales, and I don't remember any Welsh-specific advice.
And just finally on this, do you remember being informed about any actions being brought in Northern Ireland about the HIV litigation?
No.
Turning to the waiver,
yes.
There's a document which has not previously been provided to you but was provided to you over the break, and I'm going to bring that up on screen now, please. DHSC 304766_068. This is not a document that you would have seen at the time,
no.
But it is a minute from Dr. Raymond to Mr. Powell, dated the 22nd of February 1991, which the inquiry has looked at before. But to give the full context, I will read all of it. It says this, heading HIV haemophilia litigation. 1. During a brief conversation with Dr. Peter Kernoff of the Royal Free Hospital, he mentioned to me that he has received a couple of writs in respect of hepatitis infection in haemophiliacs. These are individuals who are HIV negative and as such would not be covered by the HIV haemophilia general settlement. I believe that any that are HIV positive would have to agree not to raise hepatitis in any further litigation, but this obviously does not exclude those not in the scheme. Dr. Kernoff did not believe that the Department of Health was a named defendant at present, but I felt you would wish to be aware of this. That is the minute that was sent to Mr. Powell. First of all, do you have any recollection of being informed in February 1991 that there have been writs issued in respect of hepatitis infection of people with haemophilia who were not infected with HIV?
No, I don't, but I do have some thoughts in relation to this, but no, I have no recollection of being told at the time.
If I could invite you to give those thoughts, please.
Yes, certainly. I mean, it's Dr. Kernoff from the Royal Free Hospital, so these will have been writs to the Royal Free Hospital as, I think, a special health authority from, or similar. they will therefore be related almost certainly to the clinical negligence aspect, as opposed to the policy resource aspect. It would have been a claim if it had been brought by a haemophiliac in this litigation, which could have been within the carve-out for claims against health authorities for negligence in their clinical treatment. So that's probably why we weren't involved. It would not have been, therefore, banned. I'm not sure that Dr. Raymond is correct in what he says in paragraph 3. Now, I stress in what I'm saying, I'm not either seeking to replicate the advice of those advising those plaintiffs, nor of the department, nor am I acting for the department. I'm giving a view, looking at it now and seeing it. There is a difference between the undertakings given by plaintiffs, which we've looked at, and the nature of the undertaking which the settlement agreement required to be given by non-plaintiffs, which are to be found, if we can just look at it, HSOC 0023174-22, and I think I'm right in this, but I've only had about 5 minutes to look at it, so this deals with a qualifying non-plaintiff entitled to receive benefits from the New McFarlane Trust, and we looked at the carve-out for diagnosis, corresponding to their circumstances, upon signing an undertaking not to bring proceedings against any defendant or against any other government body in respect of the administration of cryoprecipitate, etc., before December 1990, save that nothing prevents a qualifying non-plaintiff from bringing proceedings in respect of the administration prior to 13th December of cryoprecipitate factor 8 or factor 9, where one, that has caused damage to such plaintiff which had not been diagnosed by the 13th December 1990, two, the damage alleged does not include infection or the risk of infection by HIV and or the hepatitis viruses. So the non-diagnosis keeps in for those non-plaintiffs other treatment damage, excluding hepatitis and HIV. But the undertaking is in respect of what's called a government body. Now, I do not know why we have that wording compared with the wording which you have at page 20 of this document, paragraph 5. And there the undertaking is not to bring fresh proceeding against any defendant or against any other government department, health authority, or treating doctor. Now, a treating doctor is undoubtedly not a government body. It appears to me, and nobody's instructed me to do it, so I'm doing this as a thinking lawyer rather than somebody's advisor, that a health authority would normally be treated as a government body. And of course, if somebody was diagnosed with HIV who was not a plaintiff, and that person also had a clinical negligence claim, I call it that for simplicity, the claims carved out against the local health authorities, then one would expect them to be put in no worse a situation than the plaintiffs. So, in other words, plaintiffs in the litigation who had a claim for treatment against the health authority, whether for hepatitis or for HIV, whether for a, if you like, full settlement, full compensation for HIV because of their treatment. For example, they did not need to be given imported factor 8 or whatever it was, or who had a claim they wanted to bring for hepatitis, wouldn't be prevented from doing so because of the carve-out from the settlement. I would have expected that if a non-plaintiff was subsequently diagnosed with HIV and also had a claim for hepatitis arising from their treatment as opposed to arising from resources, that they would either have obtained confirmation, or their lawyers would either have obtained confirmation from the McFarlane Trust that reference to, let me get the right word, spread of the virus through factor 8, as opposed to administration of the virus. So that does not prevent me bringing my claim for clinical negligence for being given hepatitis when measures could have been taken to have given me heat-treated, factored or whatever, or would have said, I'm not going to advise my client to sign that undertaking. I want first to have a carve-out so that I can pursue my clinical negligence claim. Now, I don't know whether that happened. I haven't considered it before this document arrived on my table 10 minutes ago, but I note the distinction between the two. I expect there was a reason for the difference in wording. I think it may have been that, but I'm speculating. But I'm not sure that it would be correct to characterize the undertaking, which was required by paragraph 8 of the settlement agreement, to preclude claims in clinical negligence for hepatitis.
That's
or indeed for HIV. So, for example, if somebody who was not a plaintiff had a very good claim, I should not have been given heat-treated product, and therefore, although I can only get this settlement out of the McFarlane Trust, I can still pursue my claim for full settlement against the health authority. Equally, a non-plaintiff should, in my view, have been put in the same position, and I think the wording seemed to me to permit it.
Yes. So when you're referring to non-plaintiffs there, so we're clear, you are talking about people who didn't bring a claim in the HIV litigation,
yes,
but who were allowed access to the scheme because they became infected by HIV.
They were haemophiliacs who subsequently became infected with HIV. And the aim was to bring them in and give them the same rights and the same compensation as the plaintiffs. Now, that being the case, it would have been surprising and unintended if the effect of that was that clinical negligence type claims, which were permitted outside the settlement and McFarlane Trust, would not be also open to such non-plaintiffs. Now, I have no personal knowledge of it, but certainly if anybody had asked me at the time what the position would have been, that would have been, I think, my response.
Yes. So it's certainly, if that was a consequence, it was certainly not an intended one on your part.
Certainly not intended by me. We may not have thought about it. There is a difference in the wording, and I drew attention earlier to the reference to spread of it. It struck me as being, there must be a reason we put that in, and I now draw attention to the difference between paragraph 5 and paragraph 8, and there must have been some reason for that. And the fact that it clearly excludes doctors seems to me to suggest that it was not intended to require there to be a covenant not to sue treating clinicians. But that's really as far as I can take it. Anything more would be speculation.
Thank you. That's very helpful. Another set of potential litigants, including the one who may have issued a writ to Dr. Kernoff for people who were not infected with HIV, they would not have been captured by this scheme at all. So they would not have signed any waiver, so they could go ahead and bring whatever claim they wished to bring.
Yeah.
The question I've been asked to put to you arising out of Dr. Raymond's minute of the 22nd of February is this. Do you recall Dr. Raymond or Mr. Powell or anyone else from the central defendants suggesting to you around the 22nd of February or any time thereafter that there needed to be specific reference to waiving hepatitis claims in the settlement agreement?
No, I don't. I mean, they may have done. I don't recollect it. we've looked at how the reference to hepatitis came in through the plaintiffs' drafting. If you're asking whether somebody suggested that we should, if you like, get a free pass on hepatitis claims out of this, I have no recollection of it, and I certainly would not have wanted to be party to that without it being fully discussed and openly discussed, because it would not be what we were intending to do.
When you say fully and openly discussed, you mean fully and openly discussed with the plaintiffs?
Well, certainly in the first instance to understand what we're trying to do, and then if we are trying to do something which goes beyond the settlement which was intended, then I think we'd have to say, you know, that wording, by the way, you do understand, we'll do this, because if it's something which nobody would have spotted. So if somebody somewhere thought, oh good, there's a word excluding hepatitis claim, let's keep it, I was not aware of it and would have acted differently, and it's impossible to say how, but you know, I don't. The role of counsel advising government, in my view, has always been rather different from the role of counsel advising private litigants, because there is always a duty of care, not in a legal sense, but there is a duty to help government to make the right decisions, as opposed to simply to protect its corner, like another litigant, to avoid having to pay or whatever. So I regard my duty when acting for government as being slightly different.
If I may put it this way, there was no attempt then to sneak this past the plaintiffs?
Not to my knowledge.
Now, we've seen from the documents that it was plainly an iterative process that led to the drafting of the settlement agreement. The fact that the words hepatitis and HIV came from the plaintiffs doesn't necessarily preclude the possibility that you had discussed it with them as part of the negotiation that took place. Is that fair?
That's absolutely fair, and we may well have done, for the reason which I think I tried to explain in my statement, that what we did not want to do was to resolve this litigation and find that the resource argument for self-sufficiency was raised again. So that was the importance of dealing with the hepatitis claims in that way. Of course, it didn't prevent somebody who did not contract HIV from bringing the argument, but it's unlikely that, or certainly as perceived in 1990, that people would have brought claims simply for hepatitis in relation to very difficult and what I still call novel. And I think Lord Justice Ralph Gibson described as novel claims on policy and resourcing issues.
Moving on to the deed that you just mentioned, I don't think that we need to bring it up, but if we do, then please say. Do you recall whether or not the wording of the deed that we've looked at was the product of the same sort of discussions, counsel to counsel level, between the claimants and the defendants?
The waiver deed, you mean?
The waiver deed, yes.
No, I don't actually recollect it as a document at all. I mean, I may well have been involved in it. I'm just going to go back to it, because the wording is quite wide. Any proceedings, committee. I mean, this looks to me like what I call a committee document. Everyone's had their bit into it. Any district or regional health authority or any other government body. I don't know whether it was. I don't know when it was first actually prepared. And I don't know whether it was a subject of discussion or whether it was intended by somebody to reflect what we'd agreed. My focus was on the settlement agreement and what it provided for. I don't think I even saw the terms of the new replacement McFarlane Trust.
couple of other questions about the waiver. Are you aware of any evidence that the hepatitis waiver was included as a trade-off for the government disregarding the settlement sum for the purposes of benefits?
No. I mean, we looked at benefits separately. There were questions about with benefits. I mean, I think it took a little bit of shuffling to get the Treasury to agree it in its terms. I know there were issues about how far it extended to inheritances and so on, but I don't recollect there being any trade-off. And I think if there had been, it would have been there in the exchanges. And I think I would have seen it here, but I don't recollect it. I'm not sure it would have been right anyway. I mean, it's not what we're trying to do.
When you say not right, do you mean morally not right?
In the spirit of what we were trying to achieve, it would have been inconsistent with trying to help the haemophiliacs without creating a precedent to have required a trade-off for something which wasn't included. But one has to recollect there were no claims for hepatitis damage. So I think it was a given that claims for the infection with hepatitis, whether in conjunction with HIV, were not being pursued and therefore weren't under consideration. So there was nothing to trade off. I mean, that's the best I can do, I'm afraid.
We know from some of the documents we've looked at today, and indeed from others, that there was a requirement from the government that if this settlement was going to work and take place, then there was an expectation that all or almost all plaintiffs would need to sign up for it. Firstly, is that a fair summary of the situation?
Let me be clear about this. It was certainly the wish of the government, if they were going to settle it, they were going to settle it all rather than having leftover litigation. It was, I think, implicit in the agreement by Treasury and government to compensate that those who accepted it would settle. But there was always the possibility that individuals would not. However, it's absolutely right to say that we felt that it was most unlikely that with a settlement of this kind, represented by two very senior leading counsel, Dan Brennan and Rupert Jackson, that if any individuals decided not to accept it, that they would get continued legal aid funding for it, so that in practice, if the majority accepted the recommendation and didn't sack their counsel and carry on with another team, then it would bring the litigation to an end, probably. There may well be some refuseniks, and those people who decided, I don't mean that pejoratively, but those who decided they just didn't want it, and they wanted their day in court. And as I think I put in my statement, one of the factors which led to the slightly different treatment in the variant CJD litigation was the view that those who felt passionately that they wanted to proceed should be able to do so. And that is also allied to the fact that inevitably all those who were compensated in a way which differed from their own individual chance of success in the litigation. And just to explain that, those who had seroconverted early would have a less good prospect of success if the duty of care arguments could be overcome than those who were infected later, so that there would have been a spectrum whereby some were more likely to succeed and some less likely to succeed, and a litigation compromise would have ended up with different amounts for different groups of individuals. The purpose of the scheme as put forward was a scheme which treated all those who suffered from this terrible condition equally fairly, however good or bad their prospect of success in litigation was. But I think that, as I say, in the variant CJD litigation, the view that I formed, which Stephen Irwin, who was leading counsel for the claimants, plaintiffs still in those days, agreed with, was that if anybody wanted to pursue their claim, they should be able to do so, but would have to give credit for all the benefits which they had received.
If those people were to pursue their claims in the VCJD scheme, they would firstly take advantage of the scheme and have to give credit for it, as you said.
Yes.
But how would they fund the ongoing litigation?
They would fund the ongoing litigation. Well, of course, we're now back at 2000, 2001, so legal aid has, for all practical purposes, disappeared. So they would have had to do so by what would then have been an early version conditional fee agreement where they could recover the uplift if successful. So they would have had to find lawyers who were of the view that their prospects of success were better than the percentage of likely damages reflected by the amount given to them. So in other words, if and I can't remember, if we assume that they got 40 or 50% of their likely claim value, then the odds would have had to have been significantly better than 50% for anyone to be prepared to take it on under a CFA. Or you'd have to have a benefactor who's prepared to fund it.
Was that included in the VCJD scheme in response to your experience of the HIV litigation? Any sense that those who wished to continue their claim would have been taking an enormous risk in not taking the funding and indeed having to fund the litigation themselves if they didn't get legal aid? I think it would be wrong to say that it was my experience in HIV which led me to include that. I mean, the document was produced with close involvement of Alan Milburn, then Secretary of State for Health, and the Treasury. It was put together by myself and Stephen Irwin, acting for the plaintiffs. So it was a collaborative document. And I think it arose from a sense, there was a very strong but small group of plaintiffs who felt very much that they wanted to have the right to have their day in court. And not simply to accept the compensation. I think we all thought the compensation was fair and such claims were unlikely to be pursued. If we'd formed the view that a lot of them were still likely to bring the claims, there may have been no settlement. My own view is that if it had been a condition imposed by the plaintiffs in HIV, that they should be permitted to claim, having received the compensation, it would have been significantly more difficult to get government approval and support for it. I'm going to take you to a document unrelated to that issue, DHSC 303654_108. This is a document dated the 4th of December 1990. And it is,
which we've looked at before, isn't it? This is
yes.
the one with 1/3 chance for the Treasury.
Yes. I didn't take you to it before, but it's the one that you looked at.
You told me about it, which is why I then went back and looked at it.
Exactly. And Ronald Powell to Mr. Canavan, recording a conversation with you. It's paragraph 5 that I've been asked to ask you about.
Yes.
I'll just read it to you first of all. As to whether or not there had been actual negligence in the early years on the question of self-sufficiency, he, that is you, pointed out that there are some terrible gaps. He said there was obviously quite a lot of neglect, which he thought was inevitable if money was tight and decisions were having to be made on the basis of not where can we spend money, but where can we avoid spending it. He thought, however, that this did not amount to negligence in the legal sense, and that the chances of resisting a claim, even with a sympathetic court, were 60% in our favour. The section that I've been had my attention drawn to is the comment he pointed out that there are some terrible gaps. Now, in your witness statement at paragraph 43.4, you say that I believe that this is shorthand for the fact that the documentary record was very thin and there were substantial time periods during which there was no written evidence of what steps were being taken. What I've been asked to put to you is that a more likely reading of the document is that the terrible gaps refers to a gap in steps actually being taken at the time, failure to do something. What is your response to that?
My response to that is that I don't recollect having that thought. It's also inconsistent with what I did say, that this didn't amount to negligence in the legal sense. Now, if there had been terrible gaps in terms of activity, so in other words, an instructor, please, I don't know, make arrangements to see if we can increase the facilities here, there, or other, and there had been a failure to take proper steps, that would have been negligence in the legal sense. So I think terrible gaps and neglect, I think is reference to gaps in the record. I'm sure that's right. I remember the gaps in the record. And inactivity, neglect in the sense of things not happening. If I had thought that there had actually been culpable failure to act, then I would not have said there was no negligence in the legal sense, and the advice which we gave would have been different, because that would have been clear evidence of negligence, which would have been amounted to a breach of duty if a duty of care was found to exist, and might well have fallen within the operational side, and therefore not excluded by the policy decision. Assume there is a policy decision, as I think it was Dr. Owen, who said, let's go for self-sufficiency with some estimates, and assume that he, having made that decision, there was a failure by the department to implement that in some way through carelessness, slowness, too much on a desk. That would amount to negligence and might well be in the operational sphere. So I wouldn't have given the advice that I gave, including that last sentence, if the earlier wording meant what's been suggested. So that's, I think, the best I can do. They're not my words.
Of course, they're Mr. Powell's words. Finally, on this, you have said in your evidence earlier, and indeed just now, that there were relatively few surviving documents at the time that you came to look at them in the late 1980s. I've been asked to ask this: were you not surprised by that absence of documentary records, given that the events concerned were not that long before you were looking at them back then? And did you ever ask, or were you ever told, why there were so few documents available?
I'm sure I asked. I do remember there being relatively few documents. I don't remember what the explanations were. I think I've said something in my statement. I mean, I've done quite a lot, or did in those days, quite a lot of litigation about long tail issues going back to the 20s, 30s, 40s, 50s, and even more recently. And until you get the word processor and the photocopier, you get, you get Miss Jones in the typing pool, typing a letter or a note with 2 carbons. So there are only ever 1, 2, or 3 copies of a document. And when they go into files and files get misplaced or somebody culls them, I mean, document retention policies have developed hugely. By way of example, and it's good to put these things in context, for about the first 5 or 10 years after the introduction of email, firms of solicitors, government departments, big organisations, would routinely only keep 12 months of backup and would then delete everything longer than that because there was no capacity to store them. The idea now that you can store an infinite amount of documentation allows much tougher retention policies. So I think I was surprised. I expected there to be more. I was disappointed that there wasn't more, but I don't remember being either provided with a sort of unsatisfactory explanation in the sense of culpable or being concerned that there had been some form of deliberate destruction. There just wasn't very much, but I could understand why. I don't think probably there had been sufficiently effective document retention systems. We all used routinely in those days. When I was in the army, for example, working with the Duke of Edinburgh, we had great files and you would have to cull older documents which you thought weren't important in order to make room for the new ones. So it was a different world. So yes, I was surprised. Did I think that there was something suspicious about the explanation? Not that I now remember.
Thank you, Mr. Fenwick. Those are the questions that I have for you. I turn to you, sir, to see if you...
No, I have no questions of my own.
Thank you.
Mr. Fenwick, you're not legally represented, so there's nobody else to consult. But we give all of the witnesses an opportunity to say anything further that they wish to say at the end of their evidence.
Yes, I don't know who is listening. I don't know who is here. I don't know what they are. My aim, whenever I've been in court representing government or manufacturers or other people adversely affected in this kind of way, is to make sure that the process of defending the claims, which is my job or was my job here, is done with proper sympathy for their position. Now, we never got to court, so I never had that opportunity, as I did with, for example, human growth hormone and certain other cases. But there is no doubt that this was a massive tragedy, that it was a wholly disastrous effect on the haemophiliacs, which deserves to be recognized. We recognized it in the way that was available to us at the time, but it doesn't take away any of that. And it does mean that I emphasize, it's in my written statement, I don't take time repeating it now, that my view remains stronger than ever, having learned again about all of this by reading it, that consideration of at least a selective procedure for no fault compensation in major tragedies is really worthy of reconsideration.
Well, thank you for that thought, and thank you too for your evidence and the clarity and the evident thought that you've given to it, in particular the way that you have been so obviously careful to make sure that as far as you can recollect, if you can, and the efforts which you've done to help us by, for instance, looking at papers during what would otherwise have been your tea break. It's very much appreciated. Thank you very much.
No, thank you.
Mr. Gutowski tomorrow, sir.
Yes, tomorrow, 10 o'clock, Mr. Gutowski.